Okay, folks, let's get started. In this video topic, I'm going to describe the investigative stop and how the stop differs from the less intrusive consensual encounter on the one hand, or the more intrusive arrest on the other hand. Now, the stop is the entry point for criminal enforcement. It's the lowest level of interaction between citizen and police where we're willing to conclude that some kind of control, some kind of procedural constraint is necessary. So let's jump in and take a look at the details of the doctrine here. What sources of law define a stop and establish the legal requirements of a valid stop? Mostly it's the federal constitution. There are also state constitutions that have their own definition of a stop. I'm thinking in particular of the New York Constitution. And those state constitutions, they're somewhat rare, but they impose somewhat higher obligations on state actors than the federal definition does. There are also some provisions of federal law that define when an agency can detain someone or restrict their liberty to investigate some possible violation of law. Some state statutes are relevant here. We're about to take a look at one of those. Police rules, internal department policies will sometimes tell a police officer when a stop would be appropriate or not. And then there are just social expectations about, what a police department is expected to do by the community. And because the department serves the community, wants a good relationship with the community, that becomes relevant in shaping officer behavior. So remember that we should think of these different sources of law as being in something of a hierarchy, and at least in theory, the federal constitution governs all the others. It creates a minimum set of requirements, and you can't go below those minimums, but other sources of law become relevant, as we've discussed. Now, the federal constitutional provision that's most relevant here is the Fourth Amendment. And get used to this. We're going to be talking a lot about the Fourth Amendment for a while here. Here's the critical clause: unreasonable searches and seizures. This idea of a seizure, it includes both the most serious restrictions on someone's right to move around, that would be an arrest, but it also includes a less serious form of restriction that would be a stop. Now, even though statutes aren't the typical source of a definition for an investigative stop, you do sometimes encounter statutes as relevant here. This Delaware statute's useful because it lays out two important features of this doctrine. First of all, stops are something different from arrests and something that are regulated less severely than arrests. Second, there are going to be some specific police activities that are authorized during a stop, listed here in this statute. Now, this statute is not an exhaustive list of the things that the police officers can legitimately do during a stop, but it gives you some idea of what's typically happening during a stop. So what is the constitutional definition of an investigative stop? Well, the doctrine here lays out a three-tiered structure that federal law imposes as a minimum for all state criminal justice systems. Up at the top of this three-tiered structure would be arrests. These are the most serious intrusions into a person's liberty, ability to move around. And so it has to be justified by the most serious level of justification, some kind of probable cause to believe that some crime has occurred or is occurring. The strongest level of certainty required before the agent can properly jump in and carry out an arrest. In that middle level would be a stop. A stop is a less serious intrusion into liberty than an arrest, and therefore it has to be justified by a lesser form of certainty. We call it reasonable suspicion. A stop, according to the cases in this area, would be some kind of action on the part of the police that would lead a reasonable person to believe that he or she is not free to leave. Or in some other settings, the courts say that it's a reasonable person would not feel free to terminate the encounter. If, for instance, you're stuck on a bus and officers are working their way back up the aisle, it's not that you can leave, but that you can stop the encounter. So that's the definition of a stop. And then down at the bottom of the scale here, we're talking about a consensual conversation or a consensual encounter, where the police officer is characterized as just walking around, asking for permission to talk to people. People can choose to say yes or no. They can continue with the encounter, or they can terminate it. They can stay there. They can walk away. In that level, we say nada. Nothing is required of the officer. The officer can pick out anybody for a possible, consensual conversation. So that's the three-tiered system that we are working with here. That three-tiered system is both described and applied in the Mendenhall versus United States. Now, in this case, Sylvia Mendenhall arrives at the Detroit airport from Los Angeles early in the morning. Two DEA agents, or Drug Enforcement Administration agents, are watching her. They're watching a lot of passengers. They get a little suspicious for reasons we're not quite sure of. But the agents approach her as she's walking in the concourse. They identify themselves as federal agents, although they don't say DEA. And then they ask to see her identification and airline ticket. She produces her driver's license and a ticket, but the ticket is issued in the name of Annette Ford, while the driver's license is in her name, Sylvia Mendenhall. The agents ask, well, why the different names? And she just says, well, I just felt like using that name. Now, this was not illegal back in the 70s when it happened. It's hard to imagine this in a world of tightened airport security these days. But at the time, people could fly on a name that they just made up. So there was nothing illegal about it, but the agents treated it as suspicious, even though it wasn't illegal. They ask her about her itinerary, and she says, "Oh, I was just out in California for 2 days." So now Agent Anderson says, "Well, I'm from the DEA," and all of a sudden, Mendenhall becomes shaken and extremely nervous. She had a hard time speaking. Anderson at that point says, "Would you please accompany me to the airport DEA office for further questions?" We don't know what her verbal response was, but she does follow him up a flight of stairs about 50 feet from the initial contact point. And at the office, the agent asks if she'll allow a search of her person and her handbag, and says, "You can decline." She responds, "Go ahead." And they find heroin on her at that point. Now, the court here concludes that no seizure happened before Mendenhall got into the DEA office and consented to the search. Is that consistent with psychological reality? Would citizens perceive a distinction between an officer saying, "I request your ticket. Would you please let me see your ticket?" rather than, "I have a right to look at your ticket, give it to me"? Would most people just view that as a matter of being polite, but nevertheless an assertion of authority by the police officer or by the other government agent? Over time, this line of cases has come in for a lot of criticism as being an unrealistic portrayal of the way that people normally interact with police officers and think of themselves as being free to leave or not. We'll talk more when we get together about your perspective on this and how it fits with your life experience. But for now, let's note that the court does hold that there was no seizure or no stop up until the time that Mendenhall gets to the office and consents. One final question is a pretty tricky one here. Note that the test asks whether a reasonable person in the actor's situation or the target situation would feel free to leave. The test is not, did the officer intend to stop the person? Did the officer have plans not to let the person leave? The officer's intent is only relevant to the extent that the target perceives that and it figures into their reaction, their perception of their freedom to leave. Notice also that it's not subjectively, what did this target actually think? It's an objective test. What would a reasonable person think as to their freedom to leave or their freedom to terminate the encounter? Like with all reasonable person tests, this is not quite a purely objective test. We're always asking about the perceptions of a person or a reasonable person in the actor's situation, here in the target's situation. So when we start talking about the reasonable person in tort law, or maybe more relevant for our purposes, the reasonable person in criminal law, we are often asking, would a person in this situation react with this kind of, say, self-defense? When we're asking what counts as part of the person's situation, we start asking about things that are particular to this actor. So we would say, well, you're in this particular neighborhood, you're in this place, there are 3 officers standing there. You start talking about the particulars of this interaction. Would you also be thinking about the background of this target as part of that person's situation, so that you'd ask about a reasonable person in that situation, including that person's history? We do that in criminal law sometimes. In particular, do we ask about neighborhood encounters? If I'm in a neighborhood where the police are always stopping somebody and always insisting that you're going to stay here while we talk, that might affect how quickly I believe, oh, this is one of those times when I need to stay here. Would a person's race have some impact on their reaction to a police officer's request to stay put? If I am a black male and everybody I know who gets in this situation is going to end up being stopped, would that affect how quickly I come to the view that I am no longer free to leave? So we'll be asking about exactly what counts as part of the reasonable person's situation when we get together to work with this concept in more depth. So see you then.